You've reached the end of your commercial lease. The business is moving on. But before you hand back the keys, there's one final hurdle that could cost thousands: the dilapidations claim. Hello and welcome to Blackstone Solicitors channel. And today we're talking about dilapidations claims, one of the most common and contentious issues in commercial property law. Let's start with the basics. A dilapidations claim is a demand from a landlord for the cost of repairing or reinstating a property at the end of a lease. It's based on the tenant's obligation to keep the premises in good repair and return them in the condition agreed in the lease. These claims can include everything from fixing broken fittings and repainting walls to reinstating alterations and even compensating for lost rent while repairs are carried out. And yes, they can come as a shock, especially if you haven't budgeted for them. So how does the process work? It usually begins with the landlord serving a schedule of dilapidations, a detailed list of alleged breaches, and the works needed to put things right. This is often accompanied by a quantified demand, which sets out the financial value of the claim. So, at this point, the tenant actually has the right to respond, usually with what's called a Scott schedule. This is where they itemize each claim and say whether they agree, dispute it, or maybe even propose an alternative. This is the stage where things can get a bit technical and expert advice becomes essential. At Blackstone Solicitors, we work really closely with surveyors and valuation experts to properly assess the validity of each claim. It's important to remember, not every item on a schedule of dilapidations is automatically payable. The law actually requires that claims be reasonable and proportionate. In fact, Section 18 of the Landlord and Tenant Act 1927 limits the damages a landlord can recover. They're only entitled to the diminution in value of the property caused by the disrepair, not a windfall. If the property is about to be refurbished or demolished, the claim may be significantly reduced. So what happens if there's a dispute? Well, the courts expect both parties to follow the dilapidations protocol, which is a formal pre-action procedure designed to encourage negotiation and ideally avoid litigation. This process involves exchanging information, seeking expert advice, and considering alternative dispute resolution. Most dilapidations claims are settled out of court. But if negotiations fail, the matter can proceed to litigation, where the court will examine the lease, the evidence, and the reasonableness of the claim. So, what's the best way to protect yourself? Start early. Review your lease obligations well before the end date. Conduct a pre-termination survey. And seek legal advice as soon as a claim is made. At Blackstone Solicitors, we represent both landlords and tenants in dilapidations disputes. Whether you're making a claim or defending one, we'll guide you through the process with clarity, strategy, and determination. Thanks for watching. If you found this video helpful, give it a thumbs up, subscribe for more legal insights, and share it with anyone involved in commercial property.